Okay, well, in an effort to keep us on task and on schedule for today, we're going to get our next session started. For those of you that perhaps joined late today, just by way of reminder, please feel free to submit any questions that you may have during Derek's presentation through the chat feature. There was a question that came in during the break concerning the slides. We will be sending those out to you tomorrow. Given the size of the file, what we're likely going to do is be providing you with a link that you can go to our website and download the slide deck. So keep your eyes peeled from an email from us tomorrow. So let's jump into our next session. This topic will be presented by Derek Langton and will address the 5-year anniversary of Utah's non-compete statute. Derek concentrates his practice on employment matters, particularly non-compete, non-solicitation, non-disclosure agreements, and the protection of trade secrets, as well as employment discrimination and harassment. Derek, thanks so much for being with us this morning. I'll turn the time to you.
Thanks, Jason, and good morning to everybody. I certainly look forward to the time that we can all get together in person, but we have to deal with the cards that we have, and the technology is good, so we'll just work ahead with the virtual presentations. I assume everybody now knows about the non-compete statute. I remember doing presentations in the year or two after the statute was enacted, and there were still a lot of employers that didn't know about it. But now I think everybody does know about it, and so I thought in light of the 5-year anniversary, it might be useful to do a presentation on what we know about the statute and what we don't know about the statute. I never thought the statute was particularly well drafted. I guess I have that same view about many statutes. They're just not well prepared. They're not clear. They have all kinds of ambiguities. And so I thought in the 5-year anniversary, we might have some good, clear direction from the courts on some of the ambiguities of the statute. Well, as it turns out, there have been no cases decided during that 5-year period. And as a result, I really don't have anything to say. So unless you have any questions, that's all I have today. Okay, never mind. I do have a few things to talk about, but it's true that there are no cases that have been decided. The act was enacted back in 2016. We had seen other bills in prior years. Every year it seemed like there were bills that were introduced in the legislature seeking to enact a non-compete statute, but they never went anywhere until 2016. And in 2016, the bill came out. Initially, the plan was to eliminate all non-competes with a couple of exceptions. But as you may recall, those of you that followed it, there was a fair amount of pushback by the business community. There was certainly not uniformity or consensus among the business community, but there was a lot of pushback, and it caused the legislature to rethink the statute, and there were a number of amendments before it finally got passed. The statute has an effective date of May 10th, and it grandfathered in non-competes that were entered into before that May 10th, 2016 date. And as all of us know, the single most important aspect of the new statute was the 1-year limitation, that a non-compete, in order to be valid under Utah law, could not last more than 1 day or 1 year after the last day of employment. And importantly, as I indicate here, a non-compete covenant that violates the act is void. It's not voidable. If it is more than 1 year, it's just cannot be enforced at all. Next slide. So the definition in the statute of a non-compete or post-employment restrictive covenant is, I think, relatively mundane. I mean, you can quibble about some of the language, but it is an agreement between the employer and the employee under which the employee agrees that he or she, either alone or with others, will not compete with the employer in providing products, processes, or services that are similar to those of the employer. Next slide. Now, the key provision in the statute has this language that I've highlighted. So in addition to any requirements imposed under the common law, you can only have a non-compete that lasts for no more than 1 year after the end of employment. So we still have this express reference to the common law, and all the things that we had talked about for in my presentations for many years before the statute was enacted, those are still applicable, with the exception of the temporal or the duration of the non-compete. So you still have to worry about the geographic scope of the non-compete. You've got to make sure that you've got some valid consideration. And as many of you know, there's at least one case in Utah that suggests that the continued employment of an at-will employee is sufficient consideration. In order for the non-compete to be valid, it must be reasonably necessary to protect some legitimate interest of the company. And there have been 3 of those that have been articulated by the courts. The first and probably most important is goodwill, and the second is trade secrets. And the last, which rarely applies, is an extraordinary investment in the education or training of an employee. So in order to have a valid non-compete under Utah law after the statute was enacted, you still have to have all of these common law elements, but now the non-compete can only last for 1 year. Next slide. So the statute makes clear that a non-compete, or at least the statute dealing with non-competes, does not include non-solicitation agreements or confidentiality non-disclosure agreements. And that's an important exception to keep in mind. So even if you have some concerns about only a 1 year limitation on a non-compete, it would appear under the statute that you could have a non-solicitation of customers or a non-solicitation of employees provision that could last more than 1 year. Typically, you wouldn't want it to last more than maybe 2 or 3 years at the most, just because you still might have a judge that wouldn't enforce it. But the non-solicitation provision is not restricted by the 1 year limit for non-competes. Next slide. So the statute also contains a section that is entitled Exceptions, which has 2 subparts. One of them dealing with severance agreements, or sometimes referred to as separation agreements, and then the other one dealing with non-competes in the context of the sale of a business. So I think that's important. We're going to talk about this section entitled Exceptions further in the presentation, but you can still have a post-employment restrictive covenant or a non-compete. You can have that in a reasonable severance agreement that's mutually and freely agreed upon in good faith at or after the time of termination. And then you can also have a non-compete that arises out of the sale of a business, so long as the person who is subject to the non-compete receives value in connection with the sale of a business. Next slide. So the Act defines the term sale of a business to mean, and I quote this language, a transfer of the ownership by sale, acquisition, merger, or other method of the tangible or intangible assets of the business entity, or a division or segment of the business entity. Next slide. Now, importantly, if an employer seeks to enforce a non-compete after the effective date of the act, and so the employer either files for arbitration, which is generally fairly rare, usually it's by a civil lawsuit, but if it's determined in either the arbitration or in the lawsuit that the non-compete is unenforceable, then the employer is liable for the employee's costs associated with the arbitration. Again, I said that's fairly rare. Or the attorney's fees and court costs if it goes into litigation, and any actual damages incurred by the employee. So it's really created a disincentive to file suit because it says, you know, if the non-compete is found to be unenforceable, then the employer will be liable for these things. It doesn't say it's unenforceable just because it exceeds the 1-year limit. And as many of you may know, there are all kinds of reasons in which a court may determine that a non-compete is unenforceable. For example, the geographic scope could be too large, or it could determine that there isn't a legitimate interest to protect by way of the non-compete. So now employers have to be very careful, very circumspect before they decide to file suit, because they may be liable for attorney's fees and even actual damages of the employee from the suit being filed. So it causes all companies to be more careful about filing suits to enforce non-competes. In 2018, there was an amendment. I think every year since 2016, there have been bills introduced in the legislature to make amendments, but this was the only time that actual amendments were made. And it has to deal with the broadcast industry. And I think it has to deal with largely the fact that over the years, there have been a number of big name, well-known news anchors or sports figures or weather persons on TV who were wanting to leave and go to a different station and were prevented from doing that due to a non-compete and had to sit out sometimes for several years. And so that issue caused the legislature to amend the non-compete statute to deal with that particular situation. And you can see here that in order to have a valid non-compete between a broadcasting employee and the company, it can only be valid if the employee is exempt under the FLSA, and then the non-compete is part of a written agreement of reasonable duration based on industry standards, the position of the employee's experience, geography, the party's unique circumstances, et cetera, et cetera. So limitations on when you can have the valid non-compete for broadcast employee. And then lastly, the employee has to be discharged for cause, which is not defined in the statute, or for breaching the employment contract. So if the employee is unhappy and wants to leave, that the employee can do that without worrying about the non-compete. But if the employee is discharged for cause or for breaching the employment agreement, then the non-compete will be valid. So it also provides that the 2018 amendments provide that the non-compete can only be valid for no longer than the earlier of 1 year after the date in which the employee no longer works for the company, or the day on which the original term of the employment agreement would end. And as it does with respect to other non-competes, the Act provides that if the non-compete doesn't comply with this applicable subsection, then it's void, not simply voidable. I don't know whether a lot of you have to deal with the broadcast industry. I had some cases years ago dealing with broadcast folks, but it's been a long time, and I haven't seen any active litigation involving non-competes in the broadcast industry for quite a while. Next slide. Okay, so as I said at the outset, in the more than 5 years since the Non-Compete Act went into effect, there hasn't been a single case decided either in Utah State or in federal court in which the act has been interpreted. And so all of the ambiguities that I think exist within the statute still don't have clarification. And a couple things I'm going to point out in a moment, I think are things that it would be a good thing for the legislature to take up the statute again. I indicate here, I actually did a quick search a few days ago. I haven't found a single case anywhere in the country that has cited to the Utah non-compete statute. So now I would like to just talk about a few of the things that we don't know. Next slide. I think the most important issue that we still have under the Act is whether or not there is any circumstance under which an employer can have a valid non-compete that lasts for more than 1 year from the end of the employee's employment. That's a really interesting issue that I think a lot of lawyers that I have dealt with will argue about. Next slide. And they'll argue about it because of this exceptions section of the statute. I quoted this earlier. You can have a valid non-compete in connection with a severance agreement that's entered into at or after the time of termination, and you can have a non-compete that arises out of the sale of business. And it says exceptions. So does that mean that we're not subject to the 1 year limitation? I frankly have found that there are few instances in which I've had to deal with non-competes entered into in a severance agreement at the end of employment. I mean, it's really hard to convince an employee who has not been subject to a non-compete to sign a new agreement at the end of the employment relationship where the employee would agree not to compete with the employer. The employer is going to have to pay a lot of money or a lot of consideration in order to convince an employee to agree to a non-compete at the end of the employment relationship. A lot of times I do separation or severance agreements where the real point, the purpose of the severance agreement is to get the release of any potential claims from the employee. And so typically an employer is willing to pay some money. Sometimes it might only be a few weeks of compensation or a few months or maybe 6 months or a year, depending on how high level the employee is. But with respect to a non-compete, it usually only refers back to the agreement that the employee had already signed and says that that will still be in effect. If it's got a non-compete in it, that will still remain in effect even after the severance agreement. But with respect to the sale of a business, that is where a non-compete can be very, very important. If a company is paying, say, $10 million to purchase a business or $50 million, it wants to make sure that the principals of that business won't turn around and compete with the company right after the sale has occurred. And business lawyers would always say that's got to be longer than 1 year. That's just not sufficient if the company has paid $10 million or $50 million to buy the business. So that's where the biggest issue is, in my view, that the legislature needs to address this ambiguity. So can you have a non-compete under the current Utah non-compete statute that lasts for more than 1 year in the context of the sale of a business? Well, let's look again at the language before. Next slide. Here's the critical language out of the statute. for a post-employment restrictive covenant after May 10th, 2016, an employer and an employee may not enter into the non-compete for a period of more than 1 year from the day on which the employee is no longer employed by the employer. That seems pretty clear. Next slide. And as I say here, wait a minute, the title of this section of the statute is exceptions. So that's got to account for something, right? And believe me, I've had discussions with lawyers who say that exceptions heading or exceptions title means that the 1 year limitation doesn't apply. I disagree. And the case law, both from, as you can see, the US Supreme Court, as well as the Utah courts and other courts, make clear that a heading or a statutory title cannot limit the plain meaning of the text. It can only be used when it sheds light on some ambiguous word or phrase, but it's the text that counts. Next slide. So importantly, there's nothing in the text of the two subparts in the exceptions section of the statute that says that you can have a valid non-compete that lasts for more than 1 year. That's the most important part. There's nothing in the text of the statute that allows for a non-compete that lasts for more than 1 year. And yet, as I mentioned, if the company is being sold and the company, the buyer is paying an enormous sum of money, a 1 year non-compete, at least in the minds of most selling companies and most business transactional lawyers that do this kind of work, is simply insufficient. And that's where I think the legislature really needs to amend the statute to make clear that in the context of the sale of a business, you could have a non-compete that lasts for more than 1 year, maybe 3 years or even 5 years. Next slide. Well, here's another question that I have debated with lawyers since the act went into effect. You know, oftentimes the non-solicitation provisions that are included in employment agreements go beyond mere solicitation of customers or employees. So what if you have a non-solicitation provision that says that the departing employee cannot do business with or can't enter into any agreements with any of the company's customers? Well, you know, the law is pretty clear about what solicitation means. And at least, I don't think there's complete uniformity, but certainly the weight of authority throughout the country is that solicitation means the party that initiates the contact about doing business together. And so that's what a non-solicitation standing alone would prohibit, is initiating contact with somebody about doing business. But a lot of times our non-solicitation provisions go well beyond that and say you can't try to get the company, get the customer to leave us or stop doing business with us or do a reduced amount of business with it. You can't enter into any contracts with them. You know, it's well beyond mere solicitation. And a lot of lawyers have suggested that if that non-solicitation provision goes beyond mere solicitation, then it is tantamount to being a non-compete and is thus void under the statute. That's an open question, and I don't know where a Utah court would come out on that. I think it's a risky thing to have a non-solicitation provision that goes well beyond mere solicitation that lasts for more than 1 year, but a lot of companies still do it. And frankly, I mean, I've drafted those agreements, non-solicitation provisions in employment agreements that last for more than 1 year, that go beyond mere solicitation. It's a risk that we're taking when we don't have any guidance from the courts. Next slide. Here's another issue too, going back to the exceptions section of the statute, and specifically the exception that deals with a non-compete in the context of the sale of a business. So what if, in connection with the termination of an employee's employment, the company has the employee signs a settlement and release agreement that has a non-compete provision, and it contains a provision to repurchase shares of stock that the employee owns? Would that redemption of the stock fall within the exceptions provision? And again, if we look at the definition, next slide. So the definition in the Act about the term sale of a business means the transfer of the ownership by sale, acquisition, merger, or other method of the tangible or intangible assets of a business entity or a division or segment of the business entity. You know, a lot of times an employee, particularly a high-level executive in a company, might have a percentage of the shares of a business, and let's say it's 10%. Well, if we enter into an agreement with that employee, a settlement and release agreement, when he leaves and we agree to buy back his shares, does that constitute the sale of a business within this definition? You know, the definition doesn't use the word all, doesn't say all of the tangible or intangible assets of a business entity. But I think it's a tough argument to make that just buying out a portion of the company's shares that this particular employee owns would constitute the sale of a business. Certainly wouldn't be the division or segment of a business, but I don't know. We don't have any clear guidance from the Utah courts about that particular issue. So that's another one where the legislature is going to need to provide some clarification. All right, let's just talk about best practices under the Act. The first one is if you believe that a non-solicitation of customers provision or a non-solicitation of employees provision, along with a confidentiality and non-disclosure provision, would be sufficient to protect your business, then my recommendation is not to require employees to sign a non-compete provision. And I've actually been giving that recommendation for many years, long before the Utah statute went into effect. I think I've probably been giving that recommendation to clients for 20 years or more. And mainly because I know from my experience in litigating a lot of non-compete cases that judges are pretty hostile to non-compete provisions generally. They're reluctant to force an employee who has left the company and gone to another company to leave that new company, to prohibit that employee from being able to provide for his or her family. And on the other hand, judges don't have that same kind of reticence about non-solicitation of customers provision. They think that that is just almost commonsensical and enforceable. So if your company can be adequately protected by simply having a non-solicitation provision coupled with a non-disclosure provision, then that's what I would recommend that you do. If you know, there are companies where they just feel like they absolutely have to have non-compete provisions, mainly because of the sensitive nature of the trade secrets that the employee had access to. And if the employee were to be able to go to a competitor, that trade secret protection would be diluted or lost entirely. But generally, if you can get away with just a non-solicitation provision, that's what you should do. And following on the discussion I had a few minutes ago about the issue of non-solicitation provisions that go beyond mere solicitation, I think if you're going to have a non-solicitation of customers or non-solicitation of employees that prohibits more than mere solicitation of the customers or employees, like diverting, doing business with, providing services to, et cetera, then you might want to consider limiting that provision to just 1 year. I mean, that's a belt and suspenders approach to the non-solicitation provision, and probably just a good idea generally. And then my last advice about best practices is to make sure that your agreements, your non-competes, your non-solicitation provisions, your confidentiality provisions are well drafted. And I guess I'm encouraging you to make sure you use a lawyer in getting those things prepared. And I say that because I can't tell you how many times I have represented clients on non-compete matters or non-solicitation matters where I thought the agreements that they had were horrible. And I was at a disadvantage from the outset trying to enforce a very poorly drafted agreement. And as a result of that, I would say to my client, you know, when this case is over, we're going to revise your agreement. We're going to make it better. And we've done that, I don't know, probably dozens of times over the years of my practice. So make sure that your agreements are well drafted. And, you know, don't wait until you have an employee who leaves before you think about it. Go back to your agreements now, and if there is some big ambiguities or problems or, you know, anything that you need corrected, get it corrected now before your employees leave. Okay, so I mentioned before that there are no cases that have been decided by the appellate courts that provide any further clarity about some of the ambiguities in the Utah statute. But just because there are no reported decisions doesn't mean there hasn't been a lot of litigation involving non-competes. Although I would say that in the 5 years since the statute went into effect, I have seen a discernible decrease in the amount of litigation where the focus of the litigation or the main point of the litigation was to enforce a non-compete. I have seen a decrease in those kinds of cases. And my impression is that companies have been reluctant to pull the trigger on non-compete litigation due to the expense and uncertainty if they're only allowed to enforce an agreement for a 1-year period. Now, sometimes they will file a lawsuit if they catch the employee shortly after the employment relationship ends. If they catch the employee quickly starting to go after customers and working for a competitor right after the employee leaves, sometimes the employer will file suit. But I have seen a lot of litigation over the 5 years since the statute has been in effect involving non-solicitation provisions, because that's still active kind of litigation stuff. I mean, the things that employers really want to protect is their customers. And so they're still willing to file suit to enforce non-solicitation provisions. And I've had a couple of significant cases just this year dealing with non-solicitation provisions, at least largely dealing with non-solicitation provisions, not as much about non-compete provisions. And a couple of these new cases that I've had this year I thought were worth talking about. Both of them have some pretty big similarities that I'll mention. In the first case, we were hired kind of relatively early in this year to represent the defendants in a case. Two guys who had worked for a company. They were both relatively high level, big producing highly compensated salespeople for the plaintiff company. And the plaintiff company was involved in door-to-door sales. One of the two guys that we were asked to represent was ultimately promoted to VP of sales. And both of these guys had been very successful in recruiting other salespeople to come to the company. And both of them became unhappy and disenchanted with certain aspects of the company, and they decided that they would probably leave. And they talked to a couple other of the salespeople, two or three other salespeople, who they sort of got together and discussed the possibility of leaving and maybe forming a new company. So they had this little cabal of about 5 guys that began to exchange text messages about their plans to leave the company. And in the text messages, they made disparaging comments about the company and about the company's top executives and the damage that they would like to do to the company because they just didn't feel that they had been treated well by the company. And as it turns out, it sort of leaked out that these two main guys were thinking about leaving. And other employees, mainly the ones that they had solicited to come onto the company, when they found out about it, they wanted to leave too. And so it turns out that there were a number of employees that were planning to leave the company. But as it turned out, one of the members of this little small 5-person cabal changed his mind and decided not to go with these other guys. And he went to the company and told the company about the plan to leave the company. And he gave them copies of all of the text messages that had been exchanged between the conspirators. And the company promptly filed suit. The company filed a motion for a TRO, or a temporary restraining order, and a motion for a preliminary injunction. And they attached all of the text messages to the papers that they filed with the court seeking the TRO. And the court issued the TRO, the temporary restraining order, before I even got hired. And when I got hired to represent these two guys, we were in a deep hole. It looked bleak from the get-go when we got hired. Nevertheless, as all good lawyers do, I mean, we tried to figure out what our position was. We met with our clients, and we quickly found that, as we all already know, there are two sides to every story. There were some good arguments that our clients had about misconduct by the company and about the interpretation of the non-solicitation provisions in the agreements that they had signed. And we quickly put together a memorandum in opposition to the motion for the preliminary injunction, where we made some of these arguments. And if I do say so myself, I really thought that the opposition memorandum was quite strong. We submitted the declarations from a number of different witnesses that supported our position. And we filed that opposition memorandum about 10 days before a scheduled hearing on the motion for preliminary injunction. And I think it caused the plaintiff to be, sort of put the plaintiff back on its heels. It realized that it had some problems with its case, and we began to negotiate with the plaintiff to talk about trying to settle the case. And we were in discussions right up until the night before the preliminary injunction hearing. And on that night, we had kind of a all night. I mean, we negotiated well into the hours of the night to see if we could get this case settled, and we were able to do so on terms that were satisfactory to all sides. And as all of you probably know, that means that nobody was particularly happy with the outcome. They all had to give up something But on the morning of the preliminary injunction hearing, which was going to be done virtually, we had either a WebEx or a Zoom call with the judge and told the judge that we had settled the case. From start to finish, I think our involvement in that matter lasted about, I don't know, 4 weeks or so. And but it was really interesting to see how much companies are willing to go to enforce non-solicitation provisions. Here it was mainly non-solicitation of the employees as opposed to customers, but nonetheless, that's very active. That litigation is still very active, notwithstanding the Utah statute. The second case that I dealt with earlier this year, I think we got hired probably within a matter of a few weeks after we settled the first case. And with the second case, we were hired to represent the plaintiff company. And the company that we were hired to represent was actually in the medical field, and the employees at issue here were almost exclusively nurses and almost exclusively women nurses. But there was one male employee, and the employees, like the first case, had become disenchanted and unhappy with the company for various reasons, and they decided that they were going to leave. And as with the first case, the nurses began to exchange text messages among themselves about the plan to leave, about going to work for a competitor, or maybe forming up a new competing company to compete with the existing employer, and generally about their unhappiness with the employer. And they said negative and disparaging things about the company that I was representing. One of the employees was a male, and at the last minute, he decided not to leave with the other nurses. But he was a guy that had actually worked at various different companies in this field, and he knew a guy who owned a competing company. And so he and the ringleader of the nurses began to exchange text messages with this guy that owned a competing company about the possibility of a group of these nurses coming over from the one company to either this guy's company or maybe a new company that would be created. And shortly before this planned mass exodus was to occur, the current employer, my client, got wind of the plan to leave. And the male employee, as I mentioned, changed his mind, and he told the company that he was going to stay with the company. And so I got involved, and we filed a complaint against the nurses that had left for violating their agreements and for misappropriation of trade secrets and for the regular kinds of claims that we see in this kind of situation. But when the company told me about this male employee who had changed his mind and decided to stay, I asked whether I could interview the guy, and the company said, yeah, we've talked to him. He's kind of reluctant to talk with you, but he says he'll be willing to be interviewed. And so I called the guy and asked him a whole bunch of questions about the plan of these nurses to leave and go to a competitor. And he told me some information around the edges, but on every key question that I asked him, he told me that he was unwilling to answer my question. And so we probably talked for maybe half an hour. And at the end of our conversation, I said to him, look, I can't force you to answer my questions, at least now. But understand, we have filed a lawsuit against these nurses, and I can subpoena you for a deposition in which you will then be forced to answer my questions. And I was very pleasant. I was very civil, as I always am. But the following day, I got a phone call from a lawyer who told me that he was representing that male employee. And the lawyer told me that if the company that I was representing would agree to not sue this male employee, then the male employee would be willing to talk to me and he would answer all my questions and he would provide me with any documents that he had. And I said, done. And that day we drafted an agreement that under which my client would not sue the guy so long as he was truthful, and he would have to be fully cooperative. And so within a few days, he sent me all of the text messages. And there were a lot of text messages, and they extended over a period of months. I mean, this plan to depart the company was something that was thought about for a long time before they actually left. But I also found in the documents, in the text messages, that there were kind of embedded documents that I didn't get. And in some instances, I couldn't even tell what they were. They were not legible. And I asked this guy if he would be willing to let me have a forensic computer expert make a mirror image of the hard drive of his smartphone to get the text messages where we would be able to get the documents that were embedded. And he was very reluctant to do that because he didn't want to be separated from his phone for any length of time, which is, like most of us, we can't be without our phone for more than a few minutes. But he ultimately agreed to do it if it could be done kind of late at night and into the next day on a weekend. So I had the forensic computer guy go make this mirror image and give the phone back to the guy right away. And it turns out that many of the embedded documents were client lists or patient lists that had been improperly downloaded from my client's computer systems. And much of the information in those patient lists was information covered by HIPAA. And so, contrary to what I told you a few minutes ago about the fact that there's always two sides to every story, there really isn't two sides to every story when it comes to HIPAA. I mean, it's hard to spin what is covered by HIPAA. And it turns out that these patient lists were created really for the purpose of getting, at least apparently for the purpose of getting these nurses to solicit the patients to go to the new company when they left. As a result, almost immediately after we discovered these patient lists and what had been done with them, we began to negotiate with the other side. It was essentially game over. I mean, once it became clear that HIPAA protected information was at issue, the defendants became very willing to negotiate. And even though it took us weeks, maybe even a couple of months to negotiate the terms of a settlement, we were able to do that, again, on terms that were satisfactory to everybody. But it was the text messages that paved the way to a successful resolution of the case. So what are the main takeaways of these cases? Well, first, litigation about non-solicitation provisions is alive and well and still will continue to be for the foreseeable future. But the other takeaways from this case is the issue of emails and text messages. I mean, we've known for a long time about the importance of emails in litigation. But as you can tell from these two cases, the text messages are often the most important critical pieces of evidence in modern civil litigation that will decide the outcome of cases, not just emails, but text messages. And I guess the important point to get out of this is be very careful what you say, not just in emails, but in text messages, and spread that message to your organization. Everybody that works for you should be very circumspect, very careful about what they say in text messages, because text messages are discoverable. So that's my most important takeaway from those two cases is be careful about what you say in text messages. Jason, any questions?
Derek, great job. We haven't had any questions come in yet. We still have a couple of minutes. If there's any questions for Derek, please feel free to submit those via chat. Derek, great presentation. A lot of ambiguity around the non-compete statute. Any final takeaways you want to share with the group?
Well, not really, other than I suppose if any of you have people that you know in the legislature, these issues that I've raised have been concerns that I have tried to raise with other folks in the legal community and with legislatures, and I haven't seen any action among legislators to try to get these ambiguities resolved. And most importantly, the one about whether or not you can actually have a legitimate, valid non-compete that lasts for more than 1 year. That's a big issue.
So it sounds like we need a much louder voice relating to this issue.
Yeah.
Yeah. Okay. Well, Derek, great job. I don't see any questions that have come in. Thank you so much for preparing your materials for today. Great job on the presentation. For all of you, we will start our next session promptly at 10 a.m. this morning. So we'll give you an 8-minute break, and we'll look forward to seeing you back at 10 o'clock. Derek, thanks again.
You bet. Thank you.